delighted to see even more of you back in after the break. I think the word got out that this was a happening event, and now all of the seats are filled. Thank you very much for that. It's my distinct honor to introduce both the lead players in the next program and to explain a little bit about how it came into being. George Berman, and I guess I should give his official title, is the Jean Monnet Professor of EU Law and the Walter Gellhorn Professor of Law and the Director of the International Center for International Commercial and Investment Arbitration. More or less, that's what the title is. And Alan Rao is the Mark and Judy Yudof Chair in Law. That's all fine. I know them as active participants in this process that's been going on and many of you are involved in, called the Restatement of Law on International Commercial Arbitration that the ALI sponsored those many years ago. And so we thought it would be interesting to give you a little bit a peek behind the closed door of the activities of the reporters and the advisors and the consultative committee members who have conversations. And the way the process works is that the reporters produce drafts with commentary and then reporters' notes that support the positions put. We have a body of advisors that includes many folks in this room. Yeah, they're Abby and lots of folks, and then members, consultative group members as well. But one of our advisors is Alan Rao. And Alan was, before he became an advisor to the project, he was long known to me as one of the 5 names that if I really want to feel I've taken a good look at an arbitration issue, I should read what he's written.
Oh, his name's fun.
And whether I agree with him or not, and often I do, it's always among the more penetrating essays written, and he followed through as an advisor on our project. And so as the drafts come out in the various iterations, we've always been able to count on Alan, in particular, to write a memo, meticulous and thoughtful, generally consistent with what his law review articles had said, which is too bad because we were always trying to trip him up on inconsistencies, that has added tremendous value to the process. And so when we get together in a room like this to talk about the draft at the ALI, we have conversations that go beyond Arbitration 101. And at the risk of perhaps excluding some of you, because it goes from 0 to 60 in a hurry, I thought that by formulating this kind of an exchange, we originally called it a debate, but that sounded too hostile for Pepperdine taste. So an exchange among colleagues on selected issues that typify the kinds of conversations we have during the ALI drafting process and also highlight areas of agreement but also areas of disagreement. You have to understand that the drafts we come up with are part of this synthesis of ideas, and the process of hearing out Alan and others and is very important to that, and always impact. There are always changes made after these meetings. And so what I propose to do is to frame a topic, try to give enough background so that you can come alongside, and then let them discuss it according to my nudgings and urgings and hints. And I'm going to take my discretion as moderator to do a couple other things. I'm going to deputize Professor Drahosel, whom you just heard, because he's also a reporter on the restatement. And he has a vested interest that we don't misstate things that he's worked so hard to get us to get right. And so he has standing power to raise his hand or to clarify, and if there were room, I'd make him sit up here. And as we are going to trickle into certain other subjects, notably the BG case, I will give a semi-deputization to Andrea and Jared, who have some deep interest and understanding of this case, without cutting into afternoon panels. And so the expectation is that in addition to the free-for-all up here, some of you will raise your hand and I will recognize you, and we won't do it by cards. I will repeat as necessary the question. Okay, with those ground rules before us, let me start with the question, or a cluster of questions that have to do with what we call competence. The restatement provision reads as follows. This is section 2.8. Unless the arbitration agreement provides otherwise, an arbitral tribunal may rule on issues relating to its own jurisdiction, including, but not limited to, the existence, validity, or scope of an international arbitration agreement. So the first question will be, what does that mean and what does it not mean in terms of the American system as opposed to some of our colleagues from Germany and France and other places where their concept of competence might be a little different. And then I'm going to ask George, and by the way, the focus of all of this will be on attacks on the arbitration agreement itself. I'm going to ask George to explain to us the two concepts of allocation and delegation. This flows from the fact that while the arbitral tribunal has the power to rule on its jurisdiction, in our system it is not for them to do so primarily as to some issues. And so there are a cluster of what one might call jurisdiction-related issues, some of which we regard as being, in the first instance, for the courts to decide, others that we regard as being for the arbitrators to decide, and this is the concept of allocation. Concept of delegation has to do with the question of to what extent can that basic initial allocation of issues that we're going to describe be altered by the parties' agreement. In other words, what issue related to jurisdiction can they take from what would ordinarily be the court's determination and give to the arbitrators. And part of this is going to depend on understanding very clearly what the test for delegation is. In other words, if the parties are trying to give certain issues that would otherwise be for the court to the arbitrators, how do they have to go about that? And we'll see that the first options case is very important in this regard, and the connection and the test of clear and unmistakable delegation. And then after we ventilate those sort of concepts and look for understanding, common ground, perhaps some differences, we're going to go to a very specific question about can the parties, to the extent they are in theory allowed to delegate certain jurisdictional issues to the arbitral tribunal, to what extent should they be deemed to have done so indirectly or perhaps impliedly by their selection, by their use of a broad arbitration clause in combination with institutional arbitration rules, all of which have some kind of provision that says that the tribunal shall have the power to rule on jurisdictional issues. Sometimes they say that with greater specificity and actually name the kinds of issues that they can talk about. So what can George, I get you and Alan to weigh in on just clarifying competence, because for some it's a...
Yeah. Are you going to proceed through your sub-themes, or should we take them all on
I
at once?
take them on, and I will return to them if I think they haven't been
I'm
properly
not sure I can remember them all, but I do know their theme. What you read was a fairly wide, I think, notion of competence. You included existence, you included validity. So I think that we are in the United States are not unusual in having an extremely broad view of competence, but I think it's not an overstatement to say that the arbitrators have competence to decide any and every threshold issue. Now, it doesn't mean a court won't have intervened before the arbitrators were impaneled to address those issues. But you asked me about the scope of their competence.
Right.
So I would say their competence, I stand to be corrected, but I think their competence extends not simply to the merits of the case, but to everything that I would call either jurisdictional or admissibility, and construing both of those broadly. And we might want to unpack what those two categories mean. You referred to them as well, Jan. The real difference, not uniqueness, the speciality, I think, of our notion is not its scope, but the fact that it is not in principle, categorically at least, exclusive. Competence is not exclusive in the American view of things, and it is largely in other countries. It's always France that takes the hit here, but it is, of course, as you know, that case. So we open up the question, which we'll next come to, of allocation. There are some threshold issues that obviously come within the competence of the arbitrators, but not exclusively so. And the court may intervene even before we have an arbitral tribunal. And there are others, as you've alluded to, that courts either won't touch at all or will show, immense deference to the arbitrators on that. So I would say if you're looking for the exceptionalism, and it isn't even that, I don't think, if you're looking for the exceptionalism of American law, it isn't the definition of competence, it's whether it is or not shared in any way with a court at the front end. I don't know if Alan, you agree.
Well, I have a somewhat different take on this, but let me say before we get into the substance that when Jack first suggested the idea of this panel to me, my first reaction was that George and I have talked about these issues on which we agree or disagree so many times in our writings, at the restatement meetings, at other conferences, that it may well be thought that there was nothing more to say. And then it occurred to me that George might react the way Samuel Johnson reacted when at a meeting of his literary club, another of the members proposed that we add some new members because we've had the same members for many years and we've traveled extensively over each other's minds. And Johnson retorted with some indignation, "Sir, you have not traveled over my mind, I assure you." And I think that George would probably feel the same way and would say the same thing, so that we're not going to be repeating ourselves, or it won't matter so much. I would like to separate out. I would try not to use sophisticated foreign terms like competence, and I'd like to separate out two notions. One is timing. When does the decision take place? And the other question being one of allocation. Who has the final decision-making power? And the latter is the interesting one. If something is considered a jurisdictional question, that is to say, it goes to the consent to arbitrate, we usually assume that the decision as to whether there is jurisdiction or not, the decision as to who decides whether the arbitrators have jurisdiction, is for the court. But the possibility is open in American law, and almost uniquely in American law, that this question can be finally allocated to the arbitrators themselves. And that's where we get to the first options case, in which the court, not for the first time, but for the most important time, contemplated the possibility that the parties might want to allocate that power to the arbitrators themselves, that is final decision-making power on their jurisdiction. Now, perhaps we could talk about first options. I always thought, when I was in law school, that a case can only be understood in light of the precise question the court had in front of it. The question the court had in front of it as first options is what to do about someone, Mr. Kaplan, who says he never agreed to arbitrate anything at all, and nevertheless has been roped into the arbitration. That's the core problem. Did I agree to arbitrate anything at all? Outside of that core question, the whole problem of first options, the whole problem of clear and unmistakable becomes far less important. because the arbitrator is not an officious intermeddler. He's not a stranger. He's someone that the parties have already consented to and have hired. So maybe we could talk about the allocation of decision-making power outside of the area of core consent. And maybe I could give a concrete case, because I think concrete cases are the most important. Let's assume we have a contract that provides, this is an old chestnut, for the arbitration of disputes arising out of the sale of fruit. One party wants to arbitrate a dispute about a shipment of tomatoes, and the question is whether this is governed by the arbitration clause, whether tomato is a fruit for that purpose. I think it is botanically, but not in common usage. All right, that is a jurisdictional question. That determines the jurisdiction of the arbitrators to hear tomato-related disputes. I would suggest, first options or not, it makes a lot of sense for that question to be allocated to the arbitrators and for us to presume that it should be allocated to the arbitrators. I wonder how George feels about that case.
Oh, I'm glad to answer.
Can I make one suggestion,
Yeah.
Jack? Why don't you set out 3 simple examples that everybody agrees on as far as forgery of an arbitration clause?
Now we're getting into the other question, though.
Yeah.
Oh, sorry,
Yeah,
I thought that
no.
might be-
We'll come back to, in particular, severability and
Okay.
focus on the main contract and defects in the main contract. But as we knew from the very beginning, these are not easily compartmentalized, and so we keep spilling over into severability. But
Okay.
but your basic point, I think, is a good one. It would be great to come up with some common ground, and maybe the starting point is this hypothetical.
Okay. What Alan has done, which is perfectly respectable, of course, is to begin to unpack consent. I assume you're okay with Mr. and Mrs. Kaplan saying consent is at stake when I'm a non-signatory and the veil is not pierceable, and that they're raising a jurisdictional question. Now, what Alan very respectably wants to do, I think, is to say, well, that doesn't pertain, at least not equally, to questions of the scope of the agreement to arbitrate. And the rationale for that usually is that it's one thing to say, I never agreed to arbitrate, and it's another thing to say, well, I did agree to arbitrate, but I didn't agree to arbitrate that. And the moment you make that distinction, the second one can readily go to the arbitrators. And I think that's the premise of what Alan is saying. I have but I'm much more Procrustean than Alan about everything. I'm not happy about unpacking consent in that fashion. I think consent of the parties is as much at stake in what they agreed to arbitrate as whether they agreed to arbitrate. Now, people respectfully disagree, but I think that is the fundamental difference between us. Where it really matters, and I think, well, I'm not sure we agree on this. So let me start by saying I would not disengage those two at this point. But if we get to your delegation point, Jack, and let's assume both of these, is it a tomato or did I sign? Is it a fruit or did I sign? Let's assume they're both equally consent infused. Let's assume they are. Delegation. Now, the restatement says, and I think most of us on the restatement agree, most, not all, that the scope, the tomato question, could be delegated. Now, Alan would change the presumption, he just told us. It would be presumed to be for the arbitrators. And the restatement says, whoa, no, there's consent at stake here, but let's make that delegable. Let's make that delegable. Now, is Mr. and Mrs. Kaplan's objection, we never signed the damn thing, is that delegable? Now, we're getting into interesting question here, because if and this is one place where we tend to disagree, if the delegation is embedded in the agreement that the party contests ever having subscribed to, I find it very hard to implement the delegation. if the delegation were extrinsic to the arbitration agreement. If it were completely extrinsic, I could understand that.
Could I just?
Yeah. Please.
So you would agree that in a post-dispute agreement about whether or not I'm bound by this agreement, whether I'm even a party to it, they could delegate in that manner, and that's what you
Yeah.
refer to as extrinsic.
Yes, and we take that view.
Yes.
And we take that view. So Alan and I are definitely drawing a distinction that's common, but I think we are drawing different inferences from it and going different distances.
Well, let's go back. I mean, I don't think we have much disagreement on the problem of Mr. Kaplan, but let's go back to the question of tomatoes. I don't think it's fair to look at consent. Consent is at issue. Another way of saying it, jurisdiction is at issue. But it's not reasonable, I think, to look at this monolithically. If the parties have agreed to arbitrate something, the question then becomes one of presumption, one of default rule. Did they, having agreed to arbitrate something, did they agree to arbitrate this dispute? Now, how do you determine that? You don't determine it by labels like clear and unmistakable. You ask, what would reasonable parties have done? The interest of most contracting parties, I would think, is to minimize cost. Costs are of two natures. There are error costs. Who knows best? Who is best capable of interpreting the agreement? Who has the comparative advantage, expertise in interpretation of what fruit means? Those are error costs. And then you have transaction costs. You want to avoid what the English call, ensure what the English call one-stop adjudication. We don't have to go to courts and to arbitrators in various layers of adjudication. It's much more efficient and reduces cost to do it all at the same time. Both of those things cut in favor of a presumption that the fruit issue, a tomato issue, should be assumed to be allocated to the arbitrators in the first instance without the need of any delegation, because that's probably the majoritarian default rule. And I was very interested in what Chris was saying about the Delaware statute earlier, because it seems to me that what the Delaware statute is saying is giving us is that same presumption about the arbitrability of scope issues. And Chris, I took him to say, that's no big deal. It goes without saying. It's what American courts have been doing. And I think that's right. Well,
You could do it that way. Parties could do it that way.
Well, it's the presumption in the statute, as I understand you were saying, about substantive arbitrability. And it is the presumption that American courts have been applying. And I think it's a sensible presumption in light of why we have presumptions in the first place, which is to reduce probable costs, and therefore in accord with the probable intention of the parties. And I haven't even mentioned the word delegation because I don't think you need it.
Okay, can I jump in?
Yeah, it'd be useful for George to talk about the derivation of the word delegation, because people ask about it, and maybe even talk about allocation, because it shows up throughout the restatement chapter 2 in particular.
Yeah. I'd be glad to do that, but I can't resist saying, if I may, that once you go down the road of saying scope questions, maybe you're not going this far, but scope questions are not consent-based. What about the absurd scenario in which you and I are landlord and tenant, and we have a lease, but we're also engaged in a completely different contract, completely different one. Maybe another contract that doesn't have an arbitration clause in it at all. Now, surely you don't want, in a case in which the claim has absolutely nothing to do with the lease, it's completely disengaged. At that extreme example, I hesitate to think that you would send that to the arbitrators, but the logic of your position, I think, is that no matter how improbable the inclusion of that dispute in the arbitration agreement is, the arbitrators get to decide it. Now, maybe you want to respond.
I think I disagree that I was saying it's not consent-based. I think it is consent-based, but it's a different kind of problem. It raises a different kind of problem, and so we need to devise the appropriate default rule for that problem. You've given me a case where I think the default presumption is probably rebutted. But in the fruit and tomato case, the default presumption, this must be for the arbitrators, because this has to be what reasonable parties interested in reducing costs would want. That presumption is very strong and unrebutted.
Okay, let's move on. It does have a line drawing
Sure.
component to it that I don't welcome. We have a lot of line drawing in this world of arbitration, and I think we don't need that one. But Jack asked about the concept of allocation and delegation. Now, allocation is relatively easy because we have been discussing presumptive location of authority throughout this discussion. And that's all allocation means in our universe. It means that we have threshold questions, and we have two decision makers, potential, and we want some degree of clarity as to what the ambit of the arbitrators is on those questions, and what the ambit of the courts is, whether they're concurrent or whether they're exclusive. So let's take as our premise that we are concerned with authority, and we're concerned about defining the authority, and indeed allocating the authority, presumably presumptively. And that's the important point. So then in the restatement, we began to wonder, not very long because it occurred to us it happens, in fact, can the parties alter the allocation? Now, altering the allocation in the direction of removing something from the arbitrators, that's to say, presumptively for the arbitrators, and reserving it to a court is, I think, completely unproblematic, because nobody has to arbitrate anything if they don't agree to. So that direction, I think you'll agree, Jack, it never worried us very much. The only thing that worried us about that was that if you did that, we would then in the restatement have to provide a choice of law rule, because we have to guide judges. And we would prefer to have as few choice of law rules in the restatement as possible. So the moment we make something delegable back to a court, then we are duty-bound as restators to guide the court as to what law they should apply. Whereas we say with enormous relief, this is for the arbitrators. We don't have to discuss choice of law. Arbitrators do that under their rules of procedure. Now, delegation in that one direction. The term, as you will remember, and advisors in the room will remember, received some criticism. It received criticism in large part because it was thought to suggest a hierarchy. It was thought to suggest that courts occupy a higher place in the hierarchy, and they delegate to an inferior. Now, of course, that's not the intention at all. And we try to now make that perfectly clear. If I were writing on a clean slate, and maybe we should do it even though we're not writing on a clean slate, I would prefer to say reallocation. But delegation is the term the Supreme Court has adopted.
Rent-to-center, I think.
Rent-to-center, and rent-to-center progeny throughout the court system. But I think reallocation is the simple way to understand this. Reallocation of, or overcoming a presumption, the result of which is to reallocate primary authority.
Yeah, just for some of my students, in fact, a reminder of what we're talking about here. We start off by saying the tribunal, and I said the black letter law is that have what we call competence to decide jurisdictional issues, and you said in your mind that is virtually without restriction, all jurisdictional issues.
I do.
And so one might say, well, I'm not making the connection here. What's all of this allocation? What's the point? The point would come, I suppose, when someone seeks to attack the award.
No,
Because, well, the tribunal can move forward. We all agree the tribunal can move forward without stopping and talk to a court about does the arbitration agreement exist. Mm-hmm. Then, however, let's assume it's preserved, the objection is preserved. the award is up for enforcement or
No,
vacation.
but this can happen even before the award, if someone asks for an injunction against the arbitration on the
Okay.
grounds the arbitrators have no
I mean,
jurisdiction.
it can and
The
will
next
happen
step when we get
at
to
the
a court,
end.
in other words,
It
whatever
will
that
certainly
is.
happen at the end. All these substantive arbitrability questions are likely to come up if they are around at the post-award stage. But what we're focusing on, and in the chapter that is coming before the ALI General Assembly in May for approval, is really addressing the question of this arising at the agreement enforcement stage. And so I do think it's alive there, though it will recur and will reappear, I think.
So now to a narrow application of what we've been calling delegation and a hot topic, I suppose, if you've been coming to the meetings. It has to do with the question of if parties can delegate jurisdictional issues, whichever ones we agree they can, some difference of opinion, can they do that, or should they be assumed to have done that by virtue of naming in their arbitration clause institutional rules that have a competence provision? That is, one that says the tribunal has the power to determine its own jurisdiction, including issues relative to the existence, scope, validity of the agreement. If that, perhaps in combination with a wide arbitration clause that says the tribunal shall decide any and all issues related to this contract, should that, assuming, again, you're going to have to take the assumption that we are looking for clear and unmistakable indication, that's the Kaplan test, does that suffice? Or, given what we just said about competence, is that ambiguous in that it could just state that the tribunal need not stop the proceeding to refer to a court jurisdictional issues, but can move forward?
Can I just reframe that question? I think the
Please.
question is a fair question, but it's phrased perhaps a little tendentiously. By the way, as I tried to say earlier, I think clear and unmistakable is one overblown latka. It really doesn't really have much to do with the scope problem. But let me rephrase the question about the rules. After the court in first option said parties may, if they wish to, delegate jurisdictional issues to arbitrators, immediately after that, the AAA amended its rules expressly for the purpose of picking up on that possibility and giving to arbitrators the power to decide with finality, as first options contemplated, jurisdictional questions. There was no particular reason at that point to amend the rules to do anything else, right? No one suggested that the arbitrators, when their jurisdiction is challenged, have to pack up their papers and turn off the lights and go away. Not a serious issue. The intent was obviously to pick up on the hint that the Supreme Court gave in first options. So I would rephrase your question. Given that legislative history, isn't it clear that when people arbitrate under AAA rules, they intend to pick up on that same assumption that the AAA drafters wanted to.
That, of course, is not.
It's not tendentious in the slightest.
No. Well, and so you're adding to the consideration of whether they actually achieved it, what they were attempting to do.
Yes, absolutely. Because I think the only way, George has said something in something, there's writings about that wasn't the subjective intention of contracting parties, but we never know what the subjective intention of contracting parties are. That's always inconclusive. But we look at the backstory, we look at the legislative history, we look at what the draftsmen were trying to do, we look at what most reasonable people would have gleaned from the language.
But if you look at the pre-Kaplan provisions used to state the competence principle, they weren't much different than the amended ones. And I know what they're trying to do, but for your average party looking at a new iteration of the ICC or ICDR rules, they're going to see yet another competence, perhaps not, except for its detail, any broader than the original one.
Well, I'm not sure. I have to compare the language, but the amendments were made, whatever they were, for the express purpose of responding to the invitation of the Supreme Court. I don't think that's
Well, I
questionable.
think
Yeah.
the change was, if I'm not mistaken, was to insert existence, for example. A plain vanilla competence clause may not single out even the existence of the arbitration agreement can be decided by the authority whose existence depends upon that. Can I reply?
No.
No.
Yeah, of course.
So I have a couple of reasons for not going that route. By the way, Alan and I occasionally agree. Okay, we occasionally agree. But I want to say for the record, there's no, I don't know folks who have the combination of being contrarian and constructive, as you do. And it's a great compliment.
Thank you.
I think, because we need that in the restatement. We do need it, and Alan performs that function. Here's my concern. First of all, there's the baseline concern that I don't care how many times you put competence in your rules, it's not exclusive. I said that a few moments ago. That's my view. So we can repeat that till whoever it is comes home. But it's not exclusive by my lights. So it can't even mean what is being attributed to it, because it simply doesn't mean exclusive. It means you are able to decide that question if it's raised before you. My second concern is the one I voiced at our last restatement meeting, and I think it has impact. I agree with Alan on the point of clear and unmistakable, not making too much of it. But I don't think it's making too much of it to say that there is a presumption. That needs to be overcome on questions of existence, for example. Now, every institutional rule I know has a competence clause in it. And the great majority of arbitration laws, at least modern ones, and certainly the UNCITRAL model law in spades, has a competence clause in it. Now, I speculate as to how many arbitrations are going to take place out there where there isn't a competence clause either in the rules or in the lex arbitri. I'll leave the arbitration agreement out. I'm not even going to entertain the prospect that we have a competence clause in the arbitration agreement. But we have, at least theoretically, 3 places where this competence clause could manifest itself. And in 2 of those 3, it is ultra common. Now, if that's the case, then I don't think, far from meeting the clear and unmistakable evidence test, it's no longer, the presumption is no longer what it was. The presumption will have shifted, practically speaking, and I want to be as practical as you do. Practically speaking, the presumption has now shifted because arbitrations that take place in a place that has no competence clause in the lex arbitri and under rules that have no competence clause are few and far between. So that troubles me a lot. And the last thing I want to say is I don't agree with Alan that the amendment of the AAA, the intention of the drafters of the AAA rules means, well, this is a little overstated, means anything when it comes to this question. I don't care what the drafters of the AAA rules meant in this context. I care what the parties meant. And I'm not prepared to say that just because David Rivkin, for example,
To take an example.
to take an example at random,
Who's not here to defend himself, I should note.
just because David Rivkin authored
And we hope he is watching them, nevertheless. Hi, David.
or co-authored the amendment to the AAA rules, I'm not prepared to impute his intent to the intent of the parties. And I think that's misguided, and if I'm not mistaken, he even has misgivings these days about whether that's a fair move to make.
Well, how do you get at the intention of the parties, given the fact that the subjective intention of contracting parties will be unknowable by definition? You have to make certain guesses. I've always thought when you interpret agreements, you make guesses based on the backstory, the legislative history, what happened to get to that point, and what the people who drafted it had in mind has to be at least a relevant piece of datum. But leaving that, if you don't agree with that, how do you get at what the intention of the parties is?
Well, first of all, I object to the use of the word legislator. I mean,
Sure,
I love
sure,
the
sure, sure,
AAA.
that's tendentious.
I love the drafters of the AAA rules, but they're not yet legislators.
Aren't you on
Fair
one of the, aren't you on the council or the
I'm a
board or
director,
something?
Yeah, but I'm not a legislator by virtue of that. So that's a problem for me. And I'm really not going into the psyche when I say what I say. I'm not trying to figure out what the parties intended, because I agree with you. It's quite inscrutable. But I am taking as my point of departure, for better or for worse, first option. I'm taking as my point of departure that first option said to the Kaplans, your signature or your subscribing to the arbitration agreement is a premise of your being bound by it. It could have been otherwise. By clear and unmistakable evidence, you could have delegated that, you could have reallocated that, but you didn't do so. Now, if you take first options away from me completely, I would then be more in your universe.
Well, I would marginalize it because of the peculiar fact situation, which is not the one we're talking about. But after first options came the Pacific Air case. Maybe we could just talk about that, and then we can go on to something else. And that was a case where the contract between the parties said no punitive damages. The question is whether the arbitrators could award RICO treble damages. That is to say, whether RICO treble damages were included in the contractual ban on punitive damages. The court said, without citing first options, that's for the arbitrators to decide. Seems to me that's very close to saying that the interpretation of the contract to the point of whether the arbitrators were authorized to award RICO damages or not is something which is presumptively given to the arbitrators themselves. And that was done without any reference to first options. Isn't that the case we're talking about? Isn't that?
Well, on Pacific Air, I think it's fair to say that the premise of that was that it was seriously arguable. It was seriously arguable whether these are punitive damages or not.
Sure.
So I think that's fundamental there. But punitive damages, and we will come to this later when we discuss exceeding the scope of authority, which I hope we will.
Coming right up.
Fairly soon. Whether the punitive damages are authority questions or not. And one can argue that they are or are not, but maybe we're already in that world right now.
That's the move I would make if I were in your shoes.
Okay.
Well, in fact, I was initially going to move, was next going to move to BG for a short spit, but now let's
reverse that
jump
order.
it
BG
and
is
go
so
to your
arcane.
question. So
Let's reverse that order.
here's the question. We're talking now about, and here's my hypothetical clause. In the contract, it says, consequential damages shall not be available under this contract. And so the award comes out and the tribunal has given what appear to be consequential damages. Is that a matter of the merits, or does that fall within the remedial jurisdiction? Is it a question of remedial jurisdiction so that the court ought to look at it not with deference and not view it as a merits, which is not one of the bases of vacatur, but as something more fundamental? And we dealt with it in the restatement, and George loses a lot of sleep over how we did so, but we can't come up with anything better, so maybe you could speak to that.
Well, we had, was it 7 alternatives? We gave the.
You had some.
Okay, I added one.
George loves alternatives.
I moved it from 6 to 7, but we already had 6, and you were responsible for that, Chris. The 6.
Out of my own free.
Okay. So here's the concern, and Jack has put it very well, and it's a sad commentary that Alan and I spent half of yesterday's cocktail party talking about this, but it's a fact. Is it an authority question? Is part of the definition of the authority of the arbitrators the remedies that they can grant? I mean, that's the fundamental question. And let me just say, for the sake of completion, that we have two U.S. cases that I'm aware of, both of which say, in effect, well, one of them says plainly, it's a merits question, It's not an authority question. And so the award cannot be vacated partially, and it can't be denied enforcement partially because of the consequential damages, because that's second-guessing the arbitrators. The other case, which is a very interesting case, was a case, it's the Fertilizer of India case, where the court awarded, the tribunal awarded consequential damages, but the tribunal went to the trouble of explaining why it was awarding damages that the parties had precluded, had foreclosed. And its reasoning was very interesting. The reasoning was the contract contains a choice of law clause. The choice of law clause designated English law, and under, I'm arbitrator now, under my understanding of English law, you lose the protection of the foreclosure of consequential damages in the case of a fundamental breach. Now that arbitrator had a good deal going for him, at least in terms of logic. He applied English law the way he understood it. As he understood it, the consequential damages clause was unenforceable. And so he did exactly what he should have done. So I'm not of the view that the fact that you award consequential damages when they are prohibited categorically means that you exceeded your authority. Just to add this, two little points. I know Alan has views on this that are at variance. I have posited the hypothetical that the consequential damages prohibition is in the arbitration clause. Now, if I'm not mistaken, Alan is of the view that it's still not an authority question.
That's right.
Okay, we established that last evening. Okay. It's not an authority question, even if it is in the arbitration clause and says something like, the arbitrator shall decide any and all disputes and shall not award consequential damages under any circumstance. I have a very hard time getting my arms around that not being a question of authority. And I also have a problem treating this question as a pure merits question. When you read a contract, you largely read about the rights and obligations of the parties. That's what you mainly read about. Then there will be an arbitration clause, and there might be a remedy clause. Now, what distinguishes that remedy clause from all the other clauses in the contract about what the rights and obligations of the seller and the buyer are is that that remedies clause is addressing the arbitrators. It is addressing them directly. It's addressing their powers. So I would not drive a wedge that is being drawn by at least one American case. I would not drive a sharp wedge between the question on the one hand of whether you resolved a question that was not put to you, the standard excess of authority. You were invited to arbitrate about fruits, and you arbitrated about something else. That's the standard excess of authority scenario. The question before us, really interesting question, I think, and I know you think it's interesting, even if we disagree, is whether there can be, and is, or should we presume there to be, a remedial dimension, and not just a subject matter dimension to the competence of the authority, I should say, of the arbitrators. And I just want to add finally that in my travels, as I mentioned last night, there is no provision of the restatement that comes in for, at minimum, criticism, at maximum, disbelief, that the restatement could possibly be understood as taking the position that an arbitrator does not exceed his or her authority by granting a remedy that the parties categorically excluded. Now, we did have 7 alternatives. We didn't like any of them. The one I liked was liked least by everybody else. And it was prompted by those 2 cases. I think it's very
not
different.
the first time.
It's one thing to say, I don't care what they said, I'm awarding consequential damages anyway. And it's another thing to do what Lord Devlin did in the fertilizer case and rationalize Now, that proposal, which was, I don't know, alternative G, that proposal was met with a purely predictable response, which was, if you allow that, if you allow an inquiry into whether the arbitrators reasoned before they awarded consequential damages, that is the proverbial camel's nose under the tent, and it's the end of arbitration. Why? Because it's a merits question. That's the premise.
Well, may I say, you get contracts that are drafted to say plaintiff shall not be claimant shall not be entitled to punitive damages. And then you have contracts that say the arbitrator shall not award punitive damages, or the arbitrator has no authority to award punitive damages. And sometimes it's in Article 1 of the contract, and sometimes it's in Article 17 of the contract. I think it's totally fanciful to think that any of this makes any difference to contracting parties who didn't have that. I can't believe they would have that in mind, and they're not drawing these fine distinctions in terms of intention. I thought the restatement position is, it doesn't make any difference whether it's in Article 1 or 17, or whether they say no authority or no punitive damages. It is all assumed to be for the arbitrator. In the Pacific Care case I mentioned, that involved a number of different contracts. Some of them said the arbitrator shall have no authority to award punitive damages. Some of them said punitive damages shall not be awarded. The Supreme Court acted as if it made absolutely no difference how the clause was phrased. In any event, it assumed it would be for the arbitrator. And I think that's absolutely right, and gets us right back to the Tomatoes case. Given the fact that we're dealing with presumptions and default rules anyway, the parties can always contract around it if they really want to limit the authority of the arbitrator. So it's a question of where you start. And I can't believe that using language that nobody pays any attention to at the drafting stage should be interpreted as a limitation on authority.
No, that's not the premise of my position. My position is exactly yours as the premise. I don't care how it's put. We drew a distinction between, do the arbitrators have the authority to award consequential damages, and does the contract allow consequential damages? I think that is as foolish as you do.
Oh, okay.
And my position does not turn on that at all. It turns on the question, a general question, of whether authority, I'm using the loaded word here, authority to grant a certain remedy is an authority question. That's all. And I don't care how the clause is phrased. I don't care how it's phrased any more than you do. But I do care about the premise that all we care about is that the arbitrators didn't resolve a case that wasn't put before them, and that's all there is to authority. And we're completely oblivious to the question of whether what the arbitrators do and can do is not an authority question. That, to me, is a truly artificial distinction. Truly artificial. And I think it militates in favor of at least allowing this to be an authority question. And we should close, Jack, with your telling the audience the magnificent solution
Well,
to which we arrived.
we're going to hear from Andrea, who's asked to intervene, but we soften the presumption by saying what some might consider weasel words, but I think it's in keeping with the best approach we could come up with. This presumption can be rebutted, however. Whether the presumption is rebutted depends on various factors bearing on the party's intent in formulating the provision, including whether the provision clearly refers to the tribunal's authority rather than contractual remedies, the negotiating history of the provision, whether the provision is located in the arbitration clause, the presence of the law, of the arbitral seat, of relevant limits on the tribunal's remedial powers, the tribunal's own reasoned assessment, or lack thereof, this was George's point, concerning the party's intent, including its characterization of the limitation in question. There was no period in there. In other words, rebuttable based on several considerations, rather than this sort of she's relinquished.
No, I was just going to offer that, the U.S. and Canadian investment treaties limit the authority of arbitrators to the award of money damages, or in the case of expropriation, to restitution of property But in the alternative, the arbitrator has to give a monetary amount for the state to choose which, I guess, option that it would prefer. And that would seem, I mean, I've always considered that to be an authority question, and that the arbitrators just did not have the authority to go beyond that. Most investment treaties don't specify. So you have the default rules under customary international law about what the arbitrators can do. Of course, in practice, they mostly give money damages because that's what people want, and because there are enforcement problems if they try to go beyond that.
Well, that reminds me to apologize for...
Do you want to reiterate Andrea's comment, because she isn't mic?
Andrea said, and I will foreshorten it considerably, that no, only because I'm not going to remember all of the eloquence, dear colleague.
I think you're making it worse rather than better.
Yeah, maybe I should just shoot myself and, Isn't it time for lunch yet, ladies? That treaties, BITs, some of and this would be the new model BIT of the United States, vintage 2012, I guess. Oh, NAFTA has this? With NAFTA, so it's been in place for a while, limits and she assumes it's an authority provision, the discretion of the tribunal to grant, it says no punitive damages, and it says in principle damages, but extraordinarily restitution. Am I remembering correctly what you said?
Restitution in the event of expropriation.
Restitution in the event of expropriation, that is, you can get your property back. With an alternative damage measure. I'm sorry, I would have taken notes if I knew Chris was going to catch me on it. And so her point was, why is that not an authority? She's always taken that to mean authority, meaning if a tribunal granted punitive damages, it would be exceeding its authority quite clearly. She brought up investor-state arbitration. I'm apologizing for having teased the BG case, but there's plenty of time after lunch to get into it, and we'll have some good commentators on it. I have time for one more question before lunch.
Do the separability thing?
Well, how many of you would give up 15 minutes of lunchtime to hear?
Yeah, right.
Alan has something very important.
I'm really going to be the heavy on that.
Yeah. We touched on the point Alan would have made if we had given him more time. Next on the agenda is lunch, but I'm looking for a hand, and I'll do a better job, apologies to Andrea, in repeating the question if you put one. Well, in that case, I want to initiate a round of applause for what I think was very stimulating, and as advertised, two heavyweights going at it, and I think we have some common ground and some that we'll never agree on.
Yes, I did.